Justice.
Justice.
Community.
Accountability.
Freedom.
Repair.
Liberation. Unlocking change.
Unlocking change.
Unlocking change. Unlocking change.
Accountability.
Accountability.
Repair, liberation.
Unlocking
change.
Unlocking change.
Unlocking change.
Unlocking
Unlocking change.
Unlocking change.
This is Colorado Radio for Justice, and this is Unlocking Change. I'm your host, JoyBelle Phelan, and today I'm in conversation with Kim Ray, co-chair at End Slavery Colorado, and David Maxted, a Denver-based civil rights and criminal defense attorney. On today's episode, we dive into the 13th Amendment, focusing on how it ended slavery, except as punishment for a crime. We also explore the history behind that exception, leading up to 2018, when Colorado voters chose to close this loophole in the state constitution. And finally, Maxted shares how labor coercion shows up in modern prisons.
Not quite just punished, but coerced. So the question with involuntary servitude or slavery is the person having to work under coercion, under being compelled or forced? So not in the exercise of free choice, but they're feeling like they have to work or else.
Hello and welcome to this episode of Unlocking Change on Colorado Radio for Justice. I'm your host today, JoyBelle Phelan, and I am joined by Kim Ray, co-chair of End Slavery Colorado, and Dave Maxted with Maxted Law. And we're going to be talking about the 13th Amendment, slavery, a recent lawsuit, and about stepping away from the headlines and really digging into the history and how things are changing in Colorado. Thank you so much for being here today.
Thank you.
Thank you for having us.
So let's start with, in 1865, the 13th Amendment formally ended slavery in the United States, but it included an exception, allowing involuntary servitude as punishment for crime. In 2018, Colorado voters removed that exception from the state constitution, and more recently, we've had a Denver District Court ruling. So let's start in 1865. Why did the 13th Amendment include an exception clause allowing involuntary servitude as punishment for crime?
With the ending of slavery, obviously not everyone was excited, right? But I think that it allowed for a loophole for people, let me, be very specific, Black people, formerly, enslaved people, for slavery to be continued. That was, in my belief, that it was the reason why there would be an exception for it to not just say there should not be any slavery or involuntary servitude, period.
Since you're talking about post-Civil War era, let's talk a little bit about how was that exception used in the decades after the Civil War?
As folks were experiencing freedom, that we saw people getting arrested and putting into chain gangs for very minor things that really shouldn't be like crimes, things such as loitering, or if there were more than so many Black people standing together, you could be arrested and thrown into chain gangs and going to prison. Even currently, prisons such as Angola were actually plantations. So those plantations shifted right over into prisons.
People in America may have heard the term convict leasing. What was that? How did that help to shape prison labor in the States?
The background of the 13th Amendment was to allow slavery and involuntary servitude for certain folks. And so convict leasing was one way that occurred. Basically, I guess people call it slavery by another name, but it was slavery essentially, where there's people getting, leased out, sold out to work because they're convicted of a crime. So the Constitution in the 13th Amendment actually allowed that legally to occur, which is kind of bizarre. But even though it was abolishing slavery, it was specifically writing into the Constitution that it was legally allowed for those convicted of a crime, not just involuntary servitude, but slavery. That's still in our Constitution and in the 13th Amendment. So that's legal today under the U.S. Constitution. So convict leasing was one manifestation of that. So it was, as Kim said, it was just a way of continuing oppression, continuing slavery through the arm of the arm of the state.
So that leads into the next question is, how did prison labor evolve from that period into this more modern correctional system that we would have now?
As the prison complex, like as it has expanded, the use of inexpensive or free labor, because there are definitely some states who still do not pay folks that are incarcerated, and it's just become commonplace of like the norm, so to speak, of like, this is what it is. It shifted to slavery underneath another name.
But I agree with Kim, and I think it's evolved over the course of the 20th century into where we are.
Mm-hmm.
So people sometimes think about it like they're imagining, I don't know, people on a chain gang or something.
Mm-hmm.
And it's not. That may have been at one time what was done. But up through the 20th century, up to now, people do really hard work in prison, very physical work out in the sun, whether it's groundskeeping, whether it's, manual labor. They're maintaining the facilities. They're cooking meals, for thousands of people in hot kitchens and doing really hard work, which is under this threat of coercion, under this threat of punishments, which are akin to involuntary servitude, in which now a district court has held can be a condition of, an unconstitutional condition of slavery or involuntary servitude.
So back in 2018, Colorado voters removed that exception language that we're talking about from Colorado's state constitution. What exactly changed in that text at that time?
So during that time, and we refer to that as Amendment A, where overwhelmingly, over 60% of folks in Colorado voted to remove the language. So previously, the Colorado Constitution read like our federal Constitution: there shall not be any slavery or involuntary servitude except for being convicted of a crime. I'm very short phrasing, but after that ballot measure passed, it became there shall not be any slavery or involuntary servitude, period.
I think one of the things we learned as we really dug into the lawsuit is, if you look back at the language of what the voters approved, the brilliant activists like him and others who got into what the voters approved, people specifically said, look, opportunities to work, voluntary labor, rehabilitation, that's great. People want opportunities to work. But what they said was going to be unconstitutional by removing that exception was forcing people, coercing people, compelling people. Voters said that the state should not have that power, period, including in prison. So give opportunities, make it voluntary, but remove the power of the state to compel it or coerce it. And so I think having that language out, but also knowing what voters were thinking about when they approved it, is really important.
So since you were involved with that, Kim, I'm curious, at that time, when you were building Amendment A, was that viewed as symbolic or substantive or somewhere in between? What was the thought process as you were creating Amendment A?
It was definitely not symbolic. We definitely expected and hoped to see change. It was not supposed to change work programs like they were to exist. People want to work. This is how people earn their money, to be able to survive. However, like David said, we did not want people to be punished. We didn't want people in solitary or restrictive housing or any of those things for choosing not to work.
What I'm hearing you say is that the point of that was just to end the exception of being forced to work in slavery conditions in our Constitution.
Exactly. And, like kind of looking in a crystal ball, we would hope that the work that folks would do would actually translate into, we would change the way that labor is viewed in prison. So we want folks to have meaningful work that would set them up for success when they come home.
So did that amendment automatically require changes in Department of Corrections policy, or does constitutional language typically require judicial interpretation?
It doesn't necessarily require that. If the department, the day that passed by voters, could have, and I would argue should have, reviewed what they were doing, reviewed policy, and made affirmative changes voluntarily to ensure that they were complying. One of the things we learned during the lawsuit and came out publicly in court was that the Department of Corrections to this day has failed to do any kind of an audit or review of their own policies to see whether they're in compliance with Amendment A, with this ending the exception. So no study has been done, no internal review, no audit to really assess in a meaningful way, are we still coercing people against their will, or are we not? Are we in compliance?
So at that time, it was changing the language in the Constitution, full stop. It didn't go past that.
For the coalition that actually worked on Amendment A, that was where we stopped.
Okay.
With hopes that, we would actually see the things that David talked about, that, Department of Corrections would say, wait, let's take a look. Are we doing this? Are there policies that we need to change? And then open the door for even possible legislation, litigation if need be, as we're seeing, those sorts of things. But that's where the coalition stopped, because we hope that that was a door that we kind of opened a little bit for folks to be able to walk through.
And I think the genesis was even before that, because people started reaching out. So people in prison were realizing, wait a minute, the law changed, the Constitution changed, but nothing's changed in here. So people start complaining, they're filing grievances, they're talking to lawyers. Wait a minute, what are our rights? What should be happening? So folks started contacting, civil rights lawyers like me, Towards Justice, advocates like Kim and the coalition. And it was just an outpouring of interest and people concerned that their rights were being violated.
So as I understand it, the central issue in this case was whether incarcerated people could be punished for refusing to work. Is that accurate?
Not quite just punished, but coerced. So the question with involuntary servitude or slavery is the person having to work under coercion, under being compelled or forced? So not in the exercise of free choice, but they're feeling like they have to work or else. It doesn't have to be punishment for a crime, but if you think about human trafficking cases where someone's required to work or else the person that's trafficking them does something bad to them, where it's physical harm or locks them in some sort of confinement or some other consequence. In prison, it's a similar thing in the sense that if you're required to work and you don't, you face these consequences, including, potential solitary confinement, restricted housing, increased level of confinement if they increase your classification, a host of other sanctions. So it's not so much the fact that it's punishment, but the fact that it's used to coerce.
It's more about power.
Correct.
Okay.
To overcome the person's will to say, you know what, I don't want to work. Like, I'm going to exercise my choice. I would rather go study something or spend my time another way or talk to my family, or maybe I feel sick and I can't go today. Well, you know what? If you don't get in the kitchen today, here's what's going to happen. And so it's used to coerce and get people to work against their will.
So this was a class action lawsuit.
Yes.
Talk us through, how does that happen? How does something go from one person curious about what their rights are to a class action lawsuit?
What makes it a class action is that the court finds that it basically, the claim would apply to a whole class of people. Okay. And so the class that the court found is everyone in the Department of Corrections who's subjected to the mandatory work policy. Okay. And so the department only allows certain folks to not work if they have, an accepted disability or other, medical condition or some other permission to not work. So the class in this case is every single person in the department who works under that mandatory work requirement.
So what did the court specifically rule?
The court granted both declaratory and injunctive relief. The declaratory relief is basically declaring that the Department of Corrections and the state, Governor Polis, is in violation of the Colorado Constitution, that people are being subjected to involuntary servitude within the department. That's unconstitutional, and it's a violation of their rights under the Colorado Constitution. So the court both found the department in violation and then granted some injunctive relief to eliminate some of the coercion that's used to force people to work.
So does this ruling eliminate prison work programs, or does it focus specifically on how refusal is handled?
Yes, it absolutely does not eliminate work programs, and that's not the intention of the lawsuit at all. So it is only to allow work to be voluntary. So it doesn't mean that any work program ends or any, the industries ends, or it doesn't affect pay or anything about voluntary work in the Department of Corrections. It is only now going to restrict what the department can do in terms of, using sanctions, using forms of punishment, using consequences to force people to work against their will.
So let's talk about some of the practical implications that this might have. I know, Kim, you have friends and family and people you care about currently incarcerated. I'm formerly incarcerated. And so I'm coming at this from did I always have jobs I liked? No, I sure didn't. I don't think anybody ever has jobs we always love, like whether you're in prison or not. But I'm curious if I'm thinking like a staff person at a Department of Corrections, if disciplinary sanctions for refusing work are limited or removed, how do correctional systems maintain structure and accountability?
I think there's a lot of ways. I mean, I'll share some of my thoughts. I'm sure Kim has some. But so, look at what happens in the community. What happens if you don't go to your job? You might lose your job. Mm-hmm. There's a lot of ways to have accountability without slavery. I mean, we do it every day in the workforce. So I don't buy that suggestion at all, which has been raised somewhat by the department. And so there's absolutely ways to have accountability and to, create work ethic. But one of the things that people talked about in the lawsuit, experts on this, and this is kind of common sense, you can't force work ethic. Work ethic is something you have to develop inherently. So giving people opportunities, encouraging, positive reinforcement, that's how you develop work ethic. To expect that someone's going to be forced to work under these terrible conditions and coercion in the prison system, and then you release them out in the community and they're suddenly going to have work ethic is ridiculous. And it's not how people learn discipline or work ethic. It has to be something that you develop. So, we had an expert testify in the case about that. And, psychologists would back that up, that it's something that if you make this voluntary, if you make it a positive program, which it already is for some folks, but let's make it positive across the board, then you're going to have better rehabilitation. You're going to have better work ethic.
I don't know anyone on earth that always loves every aspect of their jobs ever. And so I think you're right. There is an interesting opportunity here, potentially. It could be money. I mean, let's not even get into what people inside make if you don't have one of the incentive or correctional industries jobs. And are there other ways to incentivize those jobs? Because to your point, it doesn't have to be money. It could be something else. So It could be very interesting. What do you think this ruling might say about how courts interpret voter intent when constitutional language changes?
That's a very interesting question and something we thought a lot about. And I think we need to see how the decision plays out, whether they appeal it. But the voters in 2018, people have a certain understanding of what involuntary servitude means, or coercion, which is probably pretty different from what they meant back in, the 1870s. So it should mean what people understand it now. And so I think as this case develops, if there is further litigation up through the courts, it could be an opportunity to develop that the Constitution should mean what it means now. Mm-hmm. When voters said no slavery and involuntary servitude, that's what they meant now. And their understanding of it should be what holds.
So let's talk about that. So there is a window of time. The Department of Corrections can appeal this ruling, right?
Yes.
What would that process look like?
And we can appeal as well, to be clear. So
okay.
There was two parts of the lawsuit. There were claims they're called facial challenges to overturn the statutes which authorize mandatory labor in the Department of Corrections. So we may appeal the ruling dismissing those claims. The department could also appeal, portions of, or some portion of the court's ruling on the injunctive relief.
Okay.
So there could be cross appeals. There could be, a number of different scenarios.
An appeal has to be made within a certain amount of time. Is that accurate?
Yes, and that time is still running. The court's giving them some time to consider what to do.
Okay. If they don't appeal and you all decide not to appeal, what happens then?
I think that the question of what the department does next, there'd have to be some collaboration. And ideally, folks like Kim, folks with life experience and people incarcerated right now would have some input on how this is developed going forward. I think there would need to be some legislation to make this actually a reality. I think that the state, the legislature, state leadership should be looking at the ruling and then going to the drawing board with the department to say, how do we put in place a voluntary work program? What is that going to look like? How do we do some of what we're talking about today? Let's look at incentives. Let's look at a non-punitive, non-coercive approach to bring the system back in line with the Constitution. So I think legislation would be helpful and should be seriously considered to give the decision meaning and give what voters decided meaning.
Do you feel like this is part of a larger national shift in how prison labor is being understood?
Yes. So back in 2018, after we changed our constitution, we saw now 6 other states who have changed their constitution. And so it has been kind of all eyes on Colorado, as we are the first to actually win litigation on this. But even currently in Alabama, there is a prison strike going on, a work strike happening. And one of their conditions is to end forced labor. Again, not talking about wages, but stop the, punishment, the forced labor. And that is one of the things. So I think that folks are actually really paying attention and really starting to rethink, like, what are we doing and how are we doing things inside of our prisons? And even we saw the conversation in California over the summer with the fires and then there was like a large nationwide conversation around, how people are treated and the work conditions of folks that are incarcerated.
So you said 6 other states have now followed our lead. Have they also had to go this legislative route? Are they, in whatever states they are, have they kind of gone to this more incentive-based, or, how have they restructured their jobs in their prison systems, to the best of your knowledge?
There's been no changes. Again, that's why everybody's like, Colorado, what are you all doing over there? Like, show us the way. There has been I believe, in Alabama, they attempted to do some litigation. It got tossed out immediately, full stop. But folks are definitely, interested in kind of following our blueprint as we did with the ballot measure. So, like I said, we've seen it on other ballots in other states. And so folks are kind of like, so how
paying attention.
Yeah, what are you guys doing over there?
And so I'm just sort of thinking through, I think it sounds like there's already maybe some pockets of training for jobs once they come home, support in that way. So it sounds like part of what you all are hoping happens here. So number one, the lawsuit sort of needed to shine the light on, there's this thing, it's a problem, to start the conversation of how to do it better. Is that sort of was the thinking behind doing it as a lawsuit?
I think that's right. I think a lawsuit is never going to solve the problem. It's going to point it out. It's going to get hopefully some relief, but really to solve a problem like this that's system-wide, that's about policies and practices in a huge, system, many facilities.
Mhm.
You got to get buy-in. You got to get community, people impacted, their families, leadership. Everyone has to come to the table to figure this out creatively. So I think, to your point, there's a blueprint already for how to do some of this voluntarily.
Mm-hmm.
So let's expand that. Let's look at ways to make it voluntary across the board.
Is there anything that I have not asked that you feel like people need to know about?
Come out and support. Come, join the coalition. Reach out for interest. This is an ongoing movement, and it has to continue. So please support and contact him. Contact folks involved.
Yes. So
Go to the
do my shameless
Slavery,
plug.
yep,
Yes, inslaverycolorado.org, and reach out, because this is just the first step,
Mhm.
right? Because it's an ongoing piece, because even when you make change or you remove something, you have to have something to fill its spot,
Mhm.
right? And I would prefer for it to be something that we want. And so in Slavery Colorado, we'll be doing a lot of community engagement this year. Get on our mailing list, those sorts of things, to get involved, because we really do want to, we're in it for the long haul to make some really good changes.
Okay. All right. So as this moves forward, whether through appeal or policy change, what should Colorados be paying attention to in the coming months or years, depending on how long this takes?
Well, we do have, some upcoming elections coming
Yeah.
up for some really big seats. Governor, Attorney General. Pay attention. How are those folks who are those candidates talking about folks that are incarcerated?
Mm.
And also, where do they stand on slavery and those sorts of things? So I think that that's something to definitely, for us to be keeping our eyes on.
Okay.
One of the Attorney General candidates, David Seligman, leads Towards Justice, which is the nonprofit that co-counseled the litigation.
Okay.
So there are candidates, David Seligman's one, who are pro-labor, who have an understanding of the issues of labor within prison, and who I think are committed to changing it. I think we need to see whether the rest of the candidates, both for Attorney General, for Governor, are willing to make the same kind of a commitment.
Mm-hmm.
And then see if the department leadership is willing to as well. So I think it's going to take leadership to make this change a reality.
Ready. So you have been listening to Unlocking Change on Colorado Radio for Justice. I'm JoyBelle Phelan. I've been joined by Kim Ray with End Slavery Colorado and David Maxted from Maxted Law. This is clearly a complex and evolving issue, and we appreciate both of you for helping us unpack the history and the legal questions involved. Thank you so much for being here today.
Thank you.
Thanks so much.
Once again, I'm JoyBelle Phelan. I hope you'll join us for our next episode of Unlocking Change. If you're interested in just a little bit more, please check out our March 16th, 2026 episode of Up to the Minute with our conversation on the prison labor lawsuit. Unlocking Change is a production of Colorado Radio for Justice. You can catch a fresh episode of Unlocking Change one Friday a month on our airwaves. Or you can find it on demand on YouTube or wherever you get your podcasts. Thanks for listening.